the street would want to know what will be the next move of Tata Sons now after this.
Well, they are, from what we've heard from the court, they are now requesting that the Tata Sons be given 4 weeks before they can, implement this order of the NCLAT. This comes, I think, as a huge victory for Cyrus Mistry, who has been battling since 2016, since he was ousted as chairman of Tata Sons, and not much sort of was expected to change from the legal, because most of the legal fraternity believed that the board was well within its right to remove him from the chairman's position. Remember, the battle was first brought in the form of an oppression and mismanagement petition by the Mistry side against Tata Sons and 20 others. And these two firms had to first battle out on the maintainability of their petition, which was first set aside by the NCLAT. Then they went to the NCLAT, got a waiver from the Appellate Tribunal, and then argued their case back again in NCLAT. They were again, their allegations were again dismissed by the Mumbai bench of the NCLAT. And in July this year, the NCLAT had finished hearing the matter and reserved its judgment. And now we have the final verdict from the Appellate Tribunal that the action by Ratan Tata and others was illegal, and the Mistry, Cyrus Mistry, now needs to be reinstated as the executive chairman of Tata Sons. Rajat Sethi is joining us from SNR Associates. Rajat, we've been talking to you on this case for the last 3 years now. Does the verdict come as a surprise to you?
Yes, I must confess it is a bit of a surprise, but another twist in the tale, and certainly it does not seem like it will be the final chapter, because I expect Tata Sons will go to the Supreme Court at the earliest. But certainly, given what has happened over the last 3 years and the verdicts which successive courts have delivered, it is indeed a surprise.
If I can also quote some of the observations, the initial observations that we are getting from the NCLAT judgment, they have said that Tata companies have suffered a loss as a result of actions of Ratan Tata and others. And Cyrus Mistry has been able to make a clear case of oppression and mismanagement against the 20 entities they took to court. And companies' affairs were being conducted prejudicial to Cyrus Mistry as well as against interest of Tata companies. We will, get into the detail as we get the fine print of the judgment, Rajat, but what could be the consequences of what the NCLAT has held?
Yeah, no, I think if these are indeed the conclusions, then I think that will have wider consequences. One will obviously need to look at the fine print of this judgment to determine what the implications are. So it may be a bit premature to speculate, but based on the observations that you're referring to, if that is indeed the case, then, and if those observations are sustained by the Supreme Court, then certainly it will have wider implications for the group.
Okay. Rajat, stay on with us, and Sanjay Asher of Crawford Bailey is also going to join us in just a bit, but I'd like to go to my colleague Arpan Chaturvedi, who was there in court while the bench announced its ruling. Arpan, from what I understand, the NCLAT has also allowed suspension of part of its order, which is in reinstating of Mistry as executive chairman for 4 weeks now. Take us through what all did the bench say?
That's right, Payasini. So in this particular case, there were two main petitions. One was by Cyrus Mistry, which challenged his removal as the executive chairman of Tata Sons. And the other petition was by two Mistry firms, which had alleged oppression and mismanagement of minority shareholders. The NCLAT in its judgment had allowed both the pleas. It has held that the board meeting, the resolution as far as the removal of Cyrus Mistry was not in accordance with law, and which is why they have held it to be illegal. They've also ordered for restoration of Mistry as executive chairman. Now, after the judgment was pronounced, the counsels from the Tata side requested the court that since it is a going company, they would like to have a suspension of that particular part of the order for 4 weeks, indicating that they will most likely go and appeal this part of the order and the judgment in the Supreme Court. But there's no clear word on that. But that seems to be the reason why they were seeking this suspension. And of course, the NCLAT has said that while they're not inclined to stay the entire judgment, this particular aspect of the court judgment, which is relating to restoration of Mr. Mistry as the executive chairman of Tata Sons, that part has been stayed for 4 weeks.
Advan, just very quickly, they've also set aside the Tata Sons conversion from a public to private company as well. Did the NCLAT say anything more on that?
On that particular aspect, for the detailed reasons, of course, we will have to wait for the detailed judgment. But what the NCLAT has said is that the ROC was incorrect in allowing for the conversion of Tata Sons from public to a private limited company, and that has been, of course, now also set aside. That was one of the other main contentions in this case.
Okay, let's go across to Sanjay Ashar. Sanjay, does this outcome come as a surprise to you?
No, not really. Because if somebody has been removed without following the due process of law, obviously, ultimately, the law prevails in as much as the correct procedure for removal has to be followed. And so if Mr. Cyrus Mistry was removed illegally, then obviously at the final appeal stage, he has to be restored as the executive chairman of Tata Sons.
How does what can we expect, from, let's say, the petitioners, or rather the respondents in this case, which is Tata Sons and 20 other entities? They've asked for part suspension of the order for 4 weeks. Once, let's say, Cyrus Mistry is restored as the executive chairman, does that become now the new reality, or we can see more action on that front?
No, there would be a lot of action now from Supreme Court. Because obviously with this order, Tata Sons and the other companies are definitely going to appeal to the Supreme Court. And then we'll have to wait and watch as to what Supreme Court has to say on this, whether he was removed illegally or is removed legally.
Okay.
A lot of actions will now come up.
Okay, all right. We'll watch out for that appeal, once Tata Sons goes to the apex court. If I can get Rajat in. Rajat, what does it sort of mean for, in terms of precedent, in terms of the oppression and mismanagement cases that minority shareholders can take to courts now?
That, Payaswini, the jurisprudence for minority shareholders has always been there, that they can file an oppression and mismanagement action. Obviously, it's a hard burden to discharge, which is what the NCLT had concluded, that burden is not discharged in terms of whether the case for oppression and mismanagement has been made out or not. The NCLAT has reached a different conclusion. One will need to study in detail what their reasons are and whether indeed those reasons are sustainable in order to comment further. In general, I think the oppression and mismanagement jurisprudence has always been there for protection of minority shareholders. Whether this particular judgment of the NCLAT creates some new aspects or fine-tunes or creates some new nuances of the law, that one will need to read the judgment before commenting on.
Sure, and of course it's worth flagging here that the petitioner in this case was Cyrus Mistry, who had a lot of information on the goings on of Tata Sons. So coming with that kind of evidence would have weighed in the Mistry side's favor at the NCLAT. But like as Sanjay and Rajat pointed out, the action will now shift most likely to the Supreme Court. Like we mentioned, the NCLAT has allowed a part suspension of its final order with respect to reinstating Cyrus Mistry for the next 4 weeks. Perhaps once the order comes out, we'll know more on what this case means for future oppression and mismanagement cases that minority shareholders can bring to courts.